822-859-49OC. This is Wesley Robertson versus Kody Gorden. Let me get appearances, please, starting with counsel in the courtroom.
Good morning, Your Honor. Lisa Rasmussen on behalf of plaintiffs and counter defendants. My bar number is 7491.
Good morning, Mr. Friedman.
Good morning, Your Honor. Matt Friedman, 11571, on behalf of defendant and counter plaintiff or counter claimant Fraser Inouye, who is also present today via Blue Jeans, I believe, or Zoom. I apologize. We've changed mode of audio visual now.
Very good. So we are here today on defendant Fraser Inouye's motion to compel and for attorney's fees and costs and related relief. Mr. Friedman, would you like to hear my inclinations or would you like to jump into argument?
I'm always happy to hear your inclinations, but in looking at the briefing, there's some things I wanted to clarify. But Judge, please let me yield the floor to you and see where you are on this, and then I can give you kind of an update from my perspective.
Okay, so one thing I would like for you to clarify is that as I read your reply, it sounds like there's no more motion to compel. There's nothing you're seeking to compel.
Well, so Judge, yeah, I kind of figured that was where you were going to go. I was looking through the briefing on this. So candidly, in looking how our reply is styled, and I was just speaking with my staff about this, I think what was intended to be conveyed is that from what we can garner from the responses is that it is the plaintiff's claim that everything that they have has been produced. And so insofar as that seems to be the claim, then I don't know how it appears they're saying they don't have anything. Some of the notable exceptions we'd have to that, right? And that's what the point of sort of our motion was. One, for example, are documents seeking information relative to Ms. Robertson's psychological or psychiatric treatment. All that was produced was 3 months of records.
Wait. Mr. Friedman, let me pause you for a second. Was that a subject of this motion to compel? Because I don't think that's one of the requests that was at issue.
I mean, I see that it wasn't so far as the request itself was, let's go ahead and provide all of them, and there's this narrow scope. Obviously, the other thing is, so again, it's a question of, is 3 months everything that there is? And what we're looking for is, I guess, some sort of affirmative statement that that's all that's in their possession. With respect to, so I believe it was, Judge. If you don't see it there, then I understand, but I believe that it was. With respect to correspondence between the parties, right? Obviously, one of the 3 remaining claims is this loss of consortium claim. That's where we're a little confused as to what's going on. What we get in response, we get a supplemental production in, I believe, January or February of 2024, but we don't receive an accompanying pod. And when we get that says, hey, this is responsive to all of the correspondence between the parties relative to this claim, let's say, or all the correspondence between the parties about these issues, meaning the 2 plaintiffs, not the parties. I apologize, I'm being imprecise. But it's also produced with a claim of spousal privilege. And I think Your Honor can understand our perspective, which is, again, I think there's some issues with invoking privilege and then, producing them anyway, but more to the point, are we intending to maintain spousal privilege and say that none of the correspondence between the parties is something that could be admitted as evidence because it's claimed as privileged, and yet we're maintaining a claim of loss of consortium? I think that would be troubling for any trier of fact to make any understanding of. The photographs and videos, Judge, that's a major one for us. In the responsive pleading, I know Your Honor sees the limited aspects of this. You only see what's before you, which is as it should be. But in maintaining the claim, this is the first time in the opposition from new counsel, and I give her a lot of deference, as we said in some prior pleadings, because I understand she came into this sort of midstream. It's the first time that we hear that they're alleging the photographs allegedly disseminated by Mr. Inouye were actually photographs taken by his former spouse. That's not an allegation we've seen anywhere else in any of the pleadings. But again, the position is still, they don't have them. But the idea is, and why would they produce something to Fraser for his review, almost implying that they do have these photographs, but that they're not going to produce them to us because he shouldn't have them because why should he get to review photographs? But the entirety of the claim is that he has a photograph that we've done responses to our own discovery, produced everything that Fraser had after we did forensic imaging of all of his devices at the court's request. And we have no images of Miss Robertson anywhere.
Okay, Mr.
And
Friedman.
so again, it's kind of this same situation. So that's where on that point, we're talking about, well, if we're going to make an affirmative statement that this is all we have, we think there's some negative inferences that should issue. I do, candidly for the court, I think that it was an oversimplification by my office to make the statement, we don't require supplemental. I mean, to me, I do absolutely believe.
Mr. Friedman,
I'm sorry, Judge.
I'm gonna pause you for a second. Sorry, I hate interrupting, but you're,
No, please go ahead.
Here's why, okay? In fairness to both the court and to Ms. Rasmussen, your reply lacked some of these arguments that you're now making. And in fact, your reply basically said, there's nothing further to compel. The only issues that are left are the fees and the adverse inferences, right? So now you're telling me that there might actually, you're bringing up a few issues. First, you're bringing up the spousal privilege issue, which, by the way, that is not fully briefed, okay? You have not, they supplemented and they're asserting the privilege. If you have an argument to make about the privilege and whether or not the privilege can be maintained, I need much more briefing than you gave me on it. I need authorities on assertion of the spousal privilege, and they need to be they need to be indexed to what documents have been produced. If the documents, there's about 25,000 pages of communications, I think, that were produced. And if you made a slight argument a few minutes ago about how, some documents have been produced, some documents have not because there's an assertion of privilege, I think I need a lot more on that argument, including authorities. Okay, because right now I don't have any authorities or any case law that I recall reading about the spousal privilege. And a privilege motion has to be teed up correctly for this court to decide it. And I'm not going to decide it on oral argument. As far as the other substantive issues on the compel motion, given the style of your reply, the court is not prepared, and I don't know if Ms. Rasmussen is prepared to respond to anything substantively that you might put in a reply. So my inclination right now is to allow supplemental briefing.
I think that, Judge, that's a perfect recommendation, and that was what I was going to transition to, Your Honor. Obviously, that's right on point. I do believe the issues I was referencing are covered in our original motion, but certainly given the response from new counsel and the way that our reply is styled candidly, in terms of oversimplification there, I think certainly that's warranted. We can lay those issues out. So I think the one thing that would be remaining for the court, if I can streamline, and then counsel certainly can argue to it, is the argument that fees would not be warranted at this point simply because after the filing of our motion to compel, when a year had transpired, essentially nearly a year from the date of their original production, or original responses, we'd held a 234 conference timely well before the case was stayed, provided 234 correspondence, and had a meet and confer, telephonically with former counsel on these issues. And then no supplementation was provided until, I believe, August 1st, after the filing of our motion to compel. I do believe that fees would be warranted, even if it were the case. And I can tell Your Honor, in supplemental briefing, we'll show you in a granular fashion that it wasn't, right? And certainly Your Honor's well correct, and it's well placed to say you need authority, you need some detail and specificity, and we'll get that to you. So my proposal would be, if you can, Judge, if you can defer. I understand you may not be prepared to do it now. I think the fee issue is right. I don't think you get to file your initial responses in October of 2023, and then wait until after a motion to compel is filed to then file basically a very limited supplemental response, and then claim that the fact that you cured after the filing of a motion to compel would relieve you of an attorney's fees obligation. I think that argument has to fall. But certainly, I think it should go to wait on the balance of the argument. So if Your Honor was inclined to defer on that issue, I think you could award it today. But I think if you're inclined to defer on it, let us put a supplemental briefing in front of you. Let us address the issue of privilege in depth for Your Honor, because I do think we should do that, and the application of the same. And let us also provide specificity with what we meant when we say, we're not looking for additional supplementation. I think, to be fair, we are, or we're looking for an exhaustive statement that this is the totality of what exists. But I think we need to lay that out for you in a more summative fashion and provide you the requisite authority and the requisite specificity with respect to what was provided and where we see these gaps, rather than inferring, I think, which is what the reply sort of seems to be styled as, inferring that, well, this is what all they say they have, therefore, there's these gaps that can't be filled. And if that pleases the court, and if counsel's amenable to that, I'm happy to do that. If you want to give me a date, we'll get that substantive briefing. Counsel can have an opportunity to respond to it. And then it can be before the court where you have everything that you need to make a requisite decision.
Ms. Rasmussen, given the style of the reply and given my inclination to ask for supplemental briefing, do you think the attorney's fees are right today?
Your Honor, no, but for a very simple reason, that his I won't even call it an application for attorney fees. In his motion to compel, he runs out factors, but he never sets forth what amount he's seeking, and he never gives any itemized detail of the actual amount he's seeking and the time that went into the motion to compel. But let me just back up a little. As the court and counsel knows, and I appreciate counsel's deference to me, I am new to the case. So the other reason why I do not believe attorney fees are appropriate, certainly not for you to rule on today, is because he hasn't given us any itemized list of what effort went into the motion.
I usually, if I find attorney's fees are appropriate, I usually allow supplementation on the amount of fees, since everybody has to come to the hearing and do additional work anyways.
So, but I reached out to Mr. Friedman because, as the court is aware, I came into this case in late June. I reached out to him trying to understand first why there was a deadline for a motion to compel, because it's just not common. And although I could see it in the minutes and I was aware of it, and then I asked him if he would be interested in stipulating to extend that deadline so that I could understand what he was trying to compel, and I could go back and look at the meet and confer letters, which were really all I received from prior counsel. He said he didn't think that the court would extend the deadline, even if we asked. I don't really agree with that. I think you likely would have. But he didn't give me an opportunity to try and cure anything, is my point. So, and that is an issue with regard to attorney fees. But in the context of my conversation, I was saying, why don't we maybe just do a stipulation to stipulate this off? I don't even know if there's anything I need to be compelling. And I will tell the court as a courtesy that I'm not going to file a motion to compel. I know I asked to extend the deadline.
I was going to actually advance your motion to today and hear it, since there was only a limited opposition file, but is it moot now?
I looked at everything. I mean, certainly I could, but I don't believe that I need to. So I'm not going to file a motion to compel. So yes, you can vacate the motion.
Okay, yes. So I will, just for my clerk, I will, and I assume Mr. Friedman has no opposition, given his limited opposition, but I'm going to advance your motion to extend the deadline to file the motion to compel today. And given counsel's statement, I'm going to deny it without prejudice. Okay. So now back to the motion for today.
Back to the motion that's on today. I know, I wanted to let you know that as a courtesy before I forgot. So I don't think it's appropriate to address the attorney fee issue. I'm just trying to give you some context of me coming in and really trying to mitigate the situation. But Mr. Friedman also said that he'd already prepared the motion months ago and had it ready and was just gonna file it. So, I mean, that's another reason why I asked for some of this detail on the motion, what went into it. I don't have that. I understand that you would determine that at a later date. Back to the substantive issues. I just wanna comment on a couple things. I know that the court's inclined to allow supplement, but I wanna make sure I'm understanding what's going to be supplemented. Because as to the privilege issue, all of the communications were provided. It's just that I believe that parties have a right to maintain a privilege, so there was nothing that wasn't provided. It's just that they maintained their objection to be able to assert privilege. So I'm a little unclear in my own head as to why we would need I mean, to me, it's a trial issue of what would be, you know, presented in trial and what's privileged. But all of the communications, 25,000 of them, were provided to opposing counsel. So there wasn't like a privilege log that says these are being withheld because they're spousal privilege. They were all provided, it's just the objection was made.
So maybe you could amend, it is a little bit unclear, and I see how counsel might have taken from your supplemental response that there might be documents that were still being withheld.
Okay.
So maybe you could just supplement your response to request number 13, erroneously titled request number 16.
Yes.
Which you answered as supplemental response to request number 16, and just say that there are no written communications between Mr. and Mrs. Robertson from January 1st, 2020 through October 6th, 2022 in plaintiff's possession, custody, and control that are being withheld on the basis of the spousal privilege, but you're still maintaining the privilege for other purposes.
Okay.
Okay, and maybe that will clarify things for Mr. Friedman, and then maybe Mr. Friedman could decide whether or not he's going to file a separate motion on assertion of the privilege. And Mr. Friedman, I would want that actually to be a separate motion. This is a motion, it was not, in my view, it was not even fully raised in the moving papers, okay? So any motion to have deemed the privilege waived would need to be filed as a separate motion. Go ahead, Ms. Rasmussen.
And then on the other issue Mr. Friedman was talking about is the intimate photos. So perhaps I inartfully worded the response or the opposition, but my clients do not have what Fraser Inouye allegedly has. They do not have that, and that's one of the things they're saying. They don't know what intimate photos he has, which he ostensibly received from another party like Kody Gorden. She does have a set of intimate photos that were actually taken by Mr. Inouye's wife. It was an intimate photo shoot. But what we are saying is we should not have to produce those to Mr. Inouye for him to gawk at and for her to be re-victimized all over again to see all of her intimate photos so that he can say, oh no, I don't have any of those.
My reading of request number 4, and I'm guessing Mr. Friedman will confirm this, they are not looking for those photographs. I think they want the photo, if Mr. Inouye has a photograph that plaintiffs are alleging an intimate photograph. Mr. Inouye has an intimate photograph of Ms. Robertson that plaintiffs are alleging Mr. Inouye disseminated to others. And Mrs. Robertson also happens to have a copy of that photograph. I think that is what Mr. Friedman is looking for.
And they do not have that. So I hope I made that clear. I can make it clear again. I'm telling you, they do not have it.
I thought it was, clear in looking at this.
So Judge, I guess this would be, and again, I understand separate briefing on the privilege issue and supplementation regarding this. and I don't mean to interrupt if counsel is still responding, but what we just heard is that we answered the response in our pods to producing any and all documents that were in Fraser's possession, custody, or control. We did so with forensic imaging of all of his electronic devices, I believe some 6 or 7 of them. And we don't have any of those photographs or images because our contention and allegation remains that he never received them and never had them at all. And so counsel just indicated she's not bringing a motion to compel, meaning presumably she doesn't have any reason to believe that our response to that pod, and we did advance that for today, and Your Honor heard that and took it off calendar. So I guess it's a question of, when I come back to the negative inference piece, and again, we can supplement for Your Honor on with some substance and some additional definition there. But effectively, this is the very thing, Judge, that Your Honor sought to prevent by keeping stage discovery. We obviously went through Rule 11 motion round that was brought by some of the co-defendants. We went through Rule 12 motions on behalf of my client where 3 of the 6 claims against him were dismissed. And Your Honor kept stage discovery precisely because our argument all along had been that we were concerned about the notion of just a fishing expedition to drag, at the time, a number of defendants through a costly and prolonged discovery process where we tried to basically come up with our case when we didn't have our case, or at least a good faith basis to bring our case in the first place. And so the problem I guess I'm having is we've responded and said no document, video, etc. exists. He doesn't have it in his possession, custody, or control after forensic imaging. There's no objection to those responses. There's no intent to seek a motion to compel there. And then plaintiffs themselves don't have, with the exception, I understand now, counsel's argument that they have a set of photographs that were taken. I want to be clear, this is not my client's current wife. This is a former spouse who I'm assuming had her own personal relationship with the Robertsons. They were all part of this sort of club baseball community. And I'm assuming having nothing to do with Fraser, the Robertsons may have contracted with my client's former spouse to take this round of intimate photos. He has no desire to have those photos. The desire is, as Your Honor pointed out, to have a copy of whatever it is you're alleging that was an intimate private photo that my client received from someone else and then disseminated. And that's, I think, where the confusion lies with respect to that. I guess the one point of clarification I want to make was with respect to counsel and the issue of fees and the issue of the ripeness of fees, and then her request at the inception of getting into the case. I think from our limited opposition, Judge, you can see that there's some daylight between what counsel's saying we said and what our position was, and then what we've even put before the court. Our position was that there was a very specific reason the court did, again, stage discovery and had deadlines for all of these things. We didn't, in fact, say that we thought the court wouldn't advance the deadline. And in fact, we were very deferential in our limited opposition. What we said was that, while she may be new to the case, my client isn't, the plaintiffs weren't, so much time had transpired. So simply, continuing it when we had been ready to go on this motion in January of 2024, we weren't amenable to stipulating, but that we certainly, as I told her, if she requested it, we would leave it to the court's deference. And that's what we said in our limited opposition to her request to extend the deadline. So I don't think that we were misleading or in any way acted in bad faith with respect to that. I think we were very, very accurate with what we believed. As for fees, again, Judge, I see it the way Your Honor sees it, which is it's very typically my experience that we make a request, we do a Brunzel, and we simply say, look, if the court's inclined to award fees, we'll provide the court with a detailed memorandum setting forth exactly the time spent for the various legal work done in the furtherance of the motions to compel, et cetera. And that would be what we would be inclined to do to date, right? That was our intention.
Okay, so we talked a lot about request number 4. Mr. Friedman, are there things or arguments you would make in a reply about requests number 7, 8, 13, 17, 18, 19, 20 that you would put in a supplemental reply if given the opportunity?
There are, Judge.
Okay,
There are.
all right. So The supplemental reply, or rather the SIR reply, to which you will get a SIR opposition, Ms. Rasmussen, will be about, I believe, two things. First, it's going to be about the plaintiffs, or I'm sorry, Mr. Friedman, the movant's response to the supplement that Ms. Rasmussen made in her opposition, okay? So you need to respond. How has Mr. Inouye's position changed with regard to the motion to compel about these remaining requests given the supplemental responses made by the Robertsons? Okay. And Ms. Rasmussen, then you're going to get a SIR opposition as well, okay? And then Mr. Friedman, you can have the last word. It's another round of briefing. It'll be a SIR reply. I encourage you all, you do not have to do a meet and confer. Again, you've done your meet and confer, but I encourage you to do a meet and confer before you start on motion practice, because like today, the conversation we had about request number 4, some of these issues could easily be alleviated between counsel if you're able to get on the same page about what each of you are requesting, or rather what Mr. Inouye's requesting, and what the Robertsons mean, what counsel meant by her objections, so on and so forth. Some of this additional motion practice could be eliminated and narrowed for the court. I am not deciding the fees issue today because I'm not deciding the motion today. And now that we're having another round of briefing, the landscape of fees could change as well, and the arguments that each counsel may have with regard to the propriety or the impropriety of fees might change. And so if you want to address the propriety of fees, again, given the necessity of this additional round of briefing, you may do so, okay? I don't think I need the adverse inference issue any more fully briefed, but if you'd like to, that's fine as well. I'm limiting everyone on this additional round of briefing, 10 pages each. Each brief 10 pages. Let's talk about when you can get your SIR reply in. Mr. Friedman, 2 weeks sufficient?
I certainly can do 2 weeks. That's not a problem, Judge. If counsel was inclined to try to have a meet and confer, I might ask the court for a 3rd week just to allow us to perhaps have the conversation Your Honor is instructed, and then therefore get the clarity necessary as far as what specifically is their position on these various items, so that to the extent that controversy remains, we can be specific and we're not wasting time in briefing, again, clarifying maybe further miscommunications or misunderstandings between us. But if Your Honor would prefer 2 weeks, I can look to expedite that. 2 weeks is not a problem. But if counsel was amenable and wanted to have the conversation, I might suggest 3 weeks just so that it allowed, for maybe a week to transpire to get that arranged.
My experience with Ms. Rasmussen is she's always amenable to meeting and conferring.
I am always amenable to meeting and conferring. I would actually prefer a little bit shorter time schedule because I have a capital case starting on October 7th.
Okay.
So if we could do 2 weeks, I would appreciate, that would be better.
So maybe 2 weeks, and then I get 7 days on the SIR, as you described it here.
Yes. So if you're able to meet and confer this week, that would be good. If you can just find a little bit of time, maybe 30 minutes, you might be able to work out most of these issues, or many of these issues. So the SIR reply will be due on the 3rd. The SIR opposition will be due on the 17th. The SIR reply will be due on the 24th, and then can we give them a hearing on October 1st? October 8th would be the soonest, okay? So if you all want to renegotiate those dates, those are fine. Go ahead.
I have that capital trial starting on the 7th. So
I'm in trial that day as well, actually. I'm glad counsel has a conflict as well, but.
How long is your capital case?
it will probably be 3 to 4 weeks.
Why don't you all go ahead and submit, I'll put it on in-chambers calendar on the 27th. If I feel like I need oral argument, I'll go ahead and call you all in for oral argument. Otherwise, I'll decide it on the papers. and we'll reach out to your office, Ms. Rasmussen, both your offices at the same time to try to coordinate a date, okay?
And there may be some mornings that I could do it,
Okay.
because sometimes we don't start till 10:30. I just don't know right now, and I don't think that I know I have something with Judge Bluth already at 8:30 on the 8th.
That's
so-
fine. My law clerk will reach out and we'll
Okay.
coordinate something if I feel like I can't decide it on the papers.
Okay, and then the other thing, Your Honor, I know this isn't before you, but I just, it is my plan and intention to file a motion for leave to amend to clean this up. So I'm just kind of announcing that, and I'm hoping to actually get that done within the next month. And I'm, of course, not asking Mr. Friedman to agree to anything. It'll be a motion seeking permission for leave to amend with the proposed complaint attached, but I just wanted to let everyone know that that is my goal.
All right, if you're able to meet and confer on that at some point as well,
Okay.
that's always helpful.
I was gonna say, counsel, happy to discuss that with you when we speak as well.
Okay.
All right, by the way, one note, Ms. Rasmussen, because I know you're new to the case. The history of the stage discovery, when there was a lot more defendants, was to try to coordinate and get this case going on some logical or sensible schedule and staging, given the amount of defendants and also given the amount of electronic information that everyone anticipated would be at issue in this case. We are, I'm not saying I'm moving away from stage discovery, but I'll also note the landscape of this case has also dramatically changed given the settlement of the remaining defendants.
And I would think that both of you would probably also agree that once I amend a complaint, it would also change again. And that hopefully will lead to a conversation as to what we can do about any other discovery.
It might, and so I encourage you all to meet and confer about this, about the amended complaint, and if Mr. Friedman is amenable to the amended complaint, also what the case schedule might look like going forward, because I believe once this motion to compel is decided, we will be at the end of stage 1 discovery.
Okay.
So it's something for everyone to discuss, and we can have a case management conference when the time comes.
Okay,
All right.
thank you.
Thank
I appreciate it.
Have a good day, everyone.
Thank you, Judge. Thank you, counsel.